Oh. How do we know this?
All right, Judge, it says it's being live streamed.
I know, I figured it out, but I've about had it with this. So this is
I
gonna
know.
be the
It's
last
live,
one. Gonna be the
It's
last
live.
one.
so. You can go ahead and either make me a co-host or let everyone in. All right, we are live streaming, so I'm going to go ahead and call it. Madam Reporter, are you ready?
I am.
19 CF 5522, State of Wisconsin versus Leroy Bryant, appearances.
Grant Huber for the state.
Roy Bryant appears in person and with Richard Hart, all by Zoom.
Here for a sentencing hearing. Where do we stand on this, gentlemen, starting with the state?
Well, Your Honor, Mr. Bryant's case was pending resolution of his mother, Angela Bryant's case. That was supposed to go to trial, I think, last week or 2 weeks before. I'm losing knowledge of space and time. Because Angela Bryant resolved her case, we are now able to go forward to sentencing on this case. And Your Honor, I know this is going to be frustrating for you. So because of the problems with the live stream, my victim witness specialist just sent the Zoom link to the victim's family because wasn't aware if you were going to be able to get it on YouTube or not. And so there should be them coming in the stream now, or in the waiting room to watch.
Lovely. Madam Clerk's a co-host. She can look in on that.
I'll let them in while they pop in during the hearing.
I think they want to be here for all of it, so I kind of, there they are.
Are they aware of the decorum in branch 12 on Zoom?
You can tell them. I'm sure they've been great every time we've had them.
Okay. All right, no one else.
I'm checking to make sure everybody's in. I'm checking with my victim witness specialist to make sure. I think everybody from the victim's family is now in, if I'm not mistaken. So I think we could proceed. No, apparently now I'm getting a chat saying, no, not everybody is in.
Oh, of course, now it is also on YouTube.
All right, I've let Mr. Thomas in as well.
All right, so I do believe that's everybody now who's been on this case, been waiting on this case.
Set for scheduling, strike that. Set for sentencing, the defendant cooperated on the case that involved his mother. His mother pled guilty within the last week. In front of me, his mother's case is scheduled for a sentencing. The defense requested, and with some reluctance, I agreed to do a sentencing over Zoom. I now more reluctance about that decision. But given that it was the defense request, and I presume it still is that correct, Mr. Hart?
Yes.
This may be the last one, but we'll proceed. The state make a record on the negotiations and agreement, and then I'll hear from Mr. Hart, and we'll go from there, please.
Yes, Your Honor. The plea agreement was as follows. The defendant originally pled to a harboring or aiding a felon, a Class G, and with the agreement that he would testify against his mother truthfully if that was required. And if that testimony did occur and was required, then upon successful completion of the defendant's agreement with the state, the state would move to amend to a Class I harboring or aiding a felon, and the state would recommend 1 year of incarceration. I would note that I have e-filed the amended information and sent a copy to defense counsel.
Mr. Hart, is that correct?
Yes, Your Honor.
You have the amended information?
I do now, and I waive reading.
All right, I'll accept the waiver of the reading. And the defendant, correct me if I'm wrong, Mr. Stewart, pled guilty already on the Class G. It's being amended now because he effectively cooperated, correct?
Yes, that is why. What the agreement was on this is that he pled guilty to a Class G. The only difference between the elements between the Class G and the Class I is the underlying level of the felony to which he harbored or aided. So it's basically a status of that crime. The state made the agreement with the defendant that if he did successfully comply with his portion, we would amend down. The reason why he did not do that in exchange for the plea was because we wanted to make certain that there was some sort of insurance that if he did not comply, that there would be, at least more time than what would normally occur in the Class I hanging over his head in case he did not follow through. But he did, and so we have filed that amended information in compliance with the negotiation between me and Mr. Hart.
Mr. Hart, that's all correct, yes?
Yes.
And this is all subject of extensive negotiations, and much of this has already been put on the record at prior hearings, correct?
All correct.
Correct. It was, and just so the court's aware, the court took a very extensive plea on this. And additionally, we had extensive testimony from Mr. Bryant during the deposition that we took of his testimony to prepare for trial.
Right. I took the plea and there was an hour, maybe 2 hours worth of testimony that occurred in a deposition format at basically the criminal justice facility in room G55 a number of months ago. So I'll hear from the state as to sentencing, please.
Thank you. Your Honor, the state's recommendation, as I indicated, was for 1 year of incarceration. I believe he will have that. And I know that the family, obviously, in any circumstance, probably would not feel the same way. But I want to be very clear about this. And I know the court's aware of it, but I think the record needs to reflect a few things. Mr. Bryant, in this case, was present. He was intoxicated. His mother was intoxicated. The victim was intoxicated. But he was present when his mother stabbed the victim multiple times. It's like over 45 times. And he was in between the two of them. He actually gets cut in the process. And he and his mother then leave the building. Now, he does not call the police. That's true. He goes over to the sister's house. When the police arrive, he doesn't tell them anything about what occurs. He says, you know, I was just involved in some fight. And he actually says, oh, I want to fight. Goes to the hospital the next day. Police are called again. He doesn't say anything to the police. But what occurs is, as the investigation leads us eventually to his sister's house, and we find out that he was present, we are able to get his DNA from the Wisconsin State Crime Lab and find that some of his blood is there from when he was cut. That does allow us to go get the defendant on a warrant. We bring him back from the state of Florida to where he had gone. And while he was in custody and had Mr. Hart as his attorney, he made a statement to a cellmate, explaining to that cellmate what his mother had done. Additionally, we always believed that his mother, Angela, was the primary, if not the sole aggressor in this case, as the court knows, because of that other acts motion, in which there were about, 14 or 15 prior stabbings of the victim by his mother. That doesn't include the fact that she currently has an open case with stabbing her new boyfriend. That doesn't include the fact that she has 4 or 5 other cases where she has stabbed the new boyfriend. It doesn't include the fact that she has stabbed Leroy several times. That doesn't include the fact that she also stabbed her daughter once or twice. So we had the reason to believe it was Angela, but we needed some witness, because no DNA put Angela in that room. No witness put Angela in that room. No fingerprints put her in that room. The only thing we had was a little bit of DNA partial from a beer bottle. Once we were able to get all of this together, Leroy, Mr. Bryant, debriefed with the state. He debriefed, he explained to us what occurred. With that, as long with the statements to her daughter that she made, where she admitted to some involvement, we now had the ability to prosecute Angela. We issued a case on her. The defendant waited for almost a year in custody for that process to work itself out. COVID hit, which delayed the process significantly. In order to preserve the testimony, Leroy testified for, I think, somewhere between 1.5 hours and 2 hours. I don't remember the exact time, in front of Your Honor in G55. I think he testified credibly. I think he testified well. I think that was a large portion of the reason why Angela pled guilty. The reality is that in this case, as I told the family, in order to sustain a conviction and to obtain a conviction against Angela Bryant for her stabbing yet another person, we needed Leroy to testify against his mother, something that is not often seen. Leroy did the right thing. Mr. Bryant did the right thing. He testified against, or agreed to testify against his mother, did testify against his mother at the deposition. And so the court is aware, showed up on the first day of trial when she pled guilty. He has complied with everything we have asked him. And I would just simply note that as a result of that, we were able to obtain that conviction against Angela Bryant. Now, in terms of a criminal record, Your Honor, in the state of Wisconsin, he does have some cases. I would note that in 2009, there is a time served disposition for carrying a concealed weapon. In 2013 and 2014, there were 2 charges for cases, but neither one of those resulted in convictions. I believe it was the same case with uncooperative victims, and they didn't result in charges. The only conviction that I have in the state of Wisconsin for which I am aware of is his CCW 3-day time served. That is what we received, and that is what my current court records show, and that includes both juvenile and adult records. So, granted, he did live in Illinois for a period of time and did go down to Florida, but I would note that that is all we have for the state of Wisconsin during that period of time. So for all those reasons, Your Honor, considering the fact that in this case, the defendant, yes, he assisted his mom in walking out, took the knife, they went to another place to change clothes, they were both bloody. Those clothes, unfortunately, were not obtained because when the police were called to his sister's house, they didn't realize there was a homicide because the body was not found for about 4 or 5 more days. So we never got those clothes. Those were disposed of. Supposedly there was a knife. We never got that. That was disposed of. So in many ways, the evidence that we needed all came down to Mr. Bryant's testimony. That was essential. That was the big piece of evidence. We lose that. I don't know we're able to convict Angela Bryant for the crime that she did. And for that reason, Your Honor, I'm asking you to follow our recommendation.
Thank you. Mr. Hart.
I'm joining in that recommendation, Your Honor. He has well over 365 days credit already, time served, 31 years of age. He's gone through high school, got a little bit technical college. The only other conviction I'm aware of is he had a possession of controlled substance, a misdemeanor. I think Indiana, for which he served 1 year probation successfully. So no other record I'm aware of. He's always been gainfully employed. The court knows he has an issue with drinking, but nonetheless, he's always been gainfully employed. Even when he got out here, he got a job right away with 2 men in a truck. He was working for them in Miami when he got arrested down there. So although he's wandered around a bit, he's always worked. So that says something positive about him. The court is aware of the history that was just given. It's kind of sad. It's kind of unbelievable, but he grew up, and his sister grew up with a mother who stabs people. She stabbed her own kids, but that's their mother. And he saw her stab the boyfriend that she eventually killed before. It's just a different world, but it's still his mother. And despite everything, he got dragged back into that. When the police contacted him in Florida, he was talking to them. He had told them he would cooperate with them, but they decided, and I understand that, to have him arrested. They did. He came back up here. I talked to him, and it was hard, but he eventually, fairly quickly, agreed to cooperate and testify. And he's been cooperative fully ever since. So he's done the right thing, even though it's extremely hard to do. I've talked to his sister numerous times. She supports him. They have their ups and downs between the two of them, as sister and brother do. But again, her sister was in the same position with her mother. That night, her sister knew her mother did something, but again, she didn't know what. But everyone could sort of guess. So despite everything, despite maybe his misguided loyalty to his mother, it's still his mother. But he did the right thing. It was very hard on him. And I think he deserves the deal that, frankly, that he was given to cooperate here. He did stay in town, and everything's going very well. So I'd ask court to sentence him to 365 days and give him credit for the 365 days, Your Honor.
Fine. Does your client want to make a statement?
I don't believe so.
Mr. Bryant, anything you want to say?
No.
Just for the record, obviously we're doing this on Zoom. As Mr. Huebner noted, there are some family members present on the Zoom link. Victims' family members. It's also being live streamed on YouTube. Looking at the appropriate factors, gravity of the offense, defendant's character, need to protect the public, along with things like punishment, deterrence, rehabilitation. The state laid it out pretty well. I'm very, very familiar with this case. I'm very, very familiar with the companion case of Angela Bryant. I have about 140 cases on my calendar in any given time, maybe 150. And I know about as much about this case and Angela Bryant's case as any of the other cases that I have. The state's recitation was rather clear. Certainly the defendant, Mr. Bryant, did certainly initially aid and harbor a fugitive. He aided and helped his mother. Eventually, it took a while, but eventually, certainly he did cooperate. Mr. Bryant's appeared in front of me, I would guess at least half a dozen times now, multiple times while he was in custody. He then did give the trial deposition a number of months ago. I agree with the state. He testified in front of me. I listened to the testimony for at least an hour and a half, and I agree with the state. I think he testified truthfully. It's far, far from an ideal situation. As Mr. Hart said, and as Mr. Huebner indicated, Ms. Bryant is someone who has an enormous propensity for stabbing pretty much everybody that she comes near. Family members, children, boyfriends, God knows who else. And the conviction in this case, Mr. Huebner is probably correct, would have been very, very difficult to obtain or maybe impossible to obtain, given that the state did not recover the knife, did not have at least substantial DNA from Ms. Bryant placing her at the scene. Clearly, I'm going to sentence Ms. Bryant when the time comes. It's not appropriate for today, but she stabbed the victim in this case dozens of times. As Mr. Huebner stated, there was a pending other acts motion because she had stabbed the victim in this case many, many other times in many, many domestic violence type cases. Unfortunately, most or all of those ended up being no process because the victim did not cooperate, which is unfortunate, but that's the reality, correct, Mr. Huebner?
Yes.
So there could have been 5 or 8 or maybe 10 other prosecutions of Ms. Bryant, but none of them occurred, or at least none of them were successful. I think a couple cases were filed and dismissed. There were multiple other referrals, and unfortunately, from what I recall and have read in this file, in this case, and from what I know from Ms. Bryant's case, the companion case, none of those resulted in a conviction, though there were many, many times that occurred. As Mr. Hart said, it's frankly sad and unfortunately pathetic that Mr. Bryant and his sister grew up with a mom that behaves the way his mother does. The defendant has accepted responsibility. He has pled guilty. As a result of this matter, he will have a conviction on his record for a felony. As Mr. Hart noted, he has served, I don't have the exact number in front of me, and I'll ask Mr. Hart after court to file the paperwork with the exact number of days, but it's certainly more than 365 days. The defendant sat in jail, much of it while COVID was fairly active and COVID-19 was adding to the problems of sitting in jail. So overall, certainly the defendant's accepted responsibility. He has a limited record that the state and defense discussed.
Your Honor, if I may, just one thing I wanted to say. In regards to this victim, none of the cases involving Miss Bryant were ever charged. Cases where she was involved with other people in domestic violence cases, those were charged and dismissed, but Mr. Meyer's cases were never charged. They were always no process.
So noted. Ultimately, the defendant has, as I said, pled guilty. He's been, after some initial reluctance, recently in the last number of months, cooperated with the court, cooperated with providing testimony. He's, as Mr. Hart noted, been employed. I think he's working right now. Is that correct, Mr. Bryan? You're at work right now?
Yes, I'm at work right now.
So all those things are positive. I don't see the need, based on what I've seen from Mr. Bryan, to have any extended supervision. He's been out for a number of months now. He's cooperated with the court. He's cooperated with the DA's office. He's employed. So I'm going to follow the recommendation. I think it's appropriate, looking at all the appropriate legal factors. I'm sentencing the defendant to 365 days, 1 year, 365 days in custody. The defendant gets credit for 365 days that he's already served. So ultimately, it's a time served outcome or a time served disposition. As part of that sentence, Mr. Bryant, because this matter is a felony, because of the conviction here, you're not allowed to own or possess a firearm, a gun, at any time ever for the rest of your life. You understand that?
Yes.
As part of the sentence, I'm not imposing a fine. I am ordering the defendant to pay all costs, fees, and surcharges. It's a mandatory and non-mandatory costs, fees, and surcharges. I'll order that those amounts are paid within 6 months. If they're not paid within 6 months, they would result in a civil judgment subject to collection, forfeiture, and tax intercept. In this case, like all cases, Mr. Bryan has the right to appeal. An appeal would have to be filed within 20 days. I'm sure he has discussed that with Mr. Hart, and Mr. Hart has filed or will file the appellate paperwork. I presume in this case, correct me if I'm wrong, Mr. Huber, the state's not asking for restitution for Mr. Bryant. Is that correct?
No, not on this case. It will be on Miss Bryant's case.
Fine. So I think that is everything I need on the sentence. I'll have my clerk verify that. But before we do that, anything else, Mr. Hart? Anything I forgot from your standpoint?
No, Your Honor.
No,
Due date will be December 7th of 2021 for the fees and costs.
Okay.
Again, I think that's all we need, but Janelle, anything else? Anything I'm forgetting?
Nope, I believe that's all, Judge.
Mr. Huber, anything else?
no, Madam Clerk, did you get the amended information?
I did. I have to do some stuff on my end to reopen the old charges, so.
Yeah, I know. I'm sorry. It's difficult, but it was the only way we could come up to make this work. I apologize.
No problem.
Thank you. And
Okay,
then,
thank you, everybody. Good
Thank
luck,
you.
Mr. Bryant.
Thank you, Your Honor.